his work in the sociology of law, but particularly his work on rights. And this is maybe not one of his best-known studies. It is actually a book which, I'm not mistaken, is not translated, but has an introduction by Brian Turner called Professional Ethics and Civil Morals. Doesn't Brian have an introduction in that? And that book has a couple of chapters that deal entirely with rights, specifically with property rights. So obviously with rights that relate to or that are very specific to organic society, but nonetheless it is a sociology of rights there too, which basically makes the argument, which is not altogether how shall I say, not altogether surprising for those of you who know a little bit about Durkheim, that the ultimate foundation of rights is social and has societal as a backup. In modern sociology, which is true, the position of rights is more ambivalent, and the treatment of rights is more ambivalent. I wouldn't say that there has been a direct line of sociology of rights in modern sociology from classical sociology. That is definitely not the case. And I think I use as an example to talk about sociology of rights the work of Jürgen Habermas. Now, it is, I think, no coincidence, of course, that Habermas is both a sociologist and a philosopher, and has both these ambitions, if you will. But it is striking that he talks about rights not only in his philosophical works or more philosophically oriented works, such as Between Facts and Norms, Faktizität und Geltung, but also in his more distinctly sociological work. And that's actually what I refer to here, which is his work on juridification, which is the last chapter in the theory of communicative action, if some of you are familiar with that. It's actually the most empirical chapter of that book, which is, after all, a theoretical statement. And he talks about, basically it is a historical model of juridification, refers to the expansion of laws, and it's an historical model of the expansion of laws that he uses specifically to explain the development of welfare law. But the important point is that he talks about laws as increasingly granting and recognizing rights, and that's the important part to me. Furthermore, he makes the point there that typically in Western European societies, there is a gradual unfolding of both liberty, individual rights, and freedom, and of equality, collective social rights. And that obviously there is an important tension between this, freedom, equality, problem, which actually many of you have been talking about too. Anyway, so it's just by example that I mention these works. The point I'm trying to make is, yes, there is a sociology of rights in the sociology of law. And I think that there is an important or peculiar misunderstanding. There often is a misunderstanding, I'm sure, by people who peek into an area that they are not working in, so probably I'm doing that now too. But in terms of the sociology of law or the sociology of policing, which is what I study, I find it usually remarkable that by non-sociologists of law, there is an understanding of law which is very naive, which is very legalistic, basically, and just the way it is in terms of policing and law enforcement. And I think that, therefore, actually, the sociology of human rights does not so much have a problem with the sociology of law, but has a problem with law, with the social role of law in society, and maybe with jurisprudence scholars, at least those jurisprudence scholars that would rather justify the role of law in society rather than take it seriously and critically. So having said that, I think that the sociology of law does not have this understanding of law that is more commonplace, like as the law. For instance, one of the first things that I say in my teaching of the sociology of law, first of all, is that this is a sociology course, not a law course, so that's from Max Weber already. But the second thing I say is that the worst understanding of law that you can have is that you say that law regulates behavior. Law is intended to regulate behavior, which is a very big difference. So I think there's a certain, which I'll talk about later, a certain legalism at work in the sociology of human rights. Now, let me also, so that's one part. The other part that I want to discuss, so that I filter out of these programmatic statements, was this sometimes very explicit activism that is embedded in the sociology of human rights. So not just as, let's say, as an application, as like something that you can do with it, but embedded in the sociology of human rights. And these statements by people like Somers, Gideon Schoberg, and Turner, that we should incorporate these normative philosophical questions. What it reminded me of course, is that in the context of the United States, this kind of embrace of human rights sociology in an activist sociology would relate to discussions on public sociology, which maybe some of you have heard of, which is a kind of a new movement. Well, it's not that new anymore maybe, but a number of years ago, 2004, 2007, were a lot of discussions on what is the role of sociology, what should sociology do more in a political, social, historical context. And there was a number of positions on that. And since I had a little bit of a role in that as a fairly lone dissenting voice, I thought, it obviously struck me that this activist orientation seems to be present in these programmatic statements, right? In these programmatic statements, not necessarily in the research. Briefly, these public sociology has two distinct components to it. One is a thematic component. You focus on certain social issues. Not so much a limited number, but a specific kind of social issues, typically, let's say, a social problem. So it's more closely related to the social problems sociology that has been existing in the United States since the 1950s. Second, indeed, it also takes on an activist orientation towards these issues. Rather than just say, let's say, we just study the conditions of inequality, we also want to do something with this knowledge. So you have both a focus on, problems, problematic situations, and, this notion that you can challenge it. The dual limitations that I bring out is, and here I want to make it immediately relevant to sociology of human rights, is that this kind of perspective, I would call it both fragmented and perverted. Well, I'm not mincing any words, obviously, right? It is fragmented because of this focus on a specific dimension of social issues, which I think is just not necessary, and which in itself, of course, already seems to make a certain, maybe that's already a political decision to make, what is it that I'm going to study? But the point is, why limit oneself at all? And so now, for me, the point to make is that the sociology of human rights, to me, should always be a sociology of rights. So I'm not saying human rights is just any one other right. I'm not saying that at all. I'm not denying I'm not denying a priori the special status of human rights relative to other rights, but I'm saying that from an analytical point of view of studying human rights sociologically, it must be a sociology of rights. Just like in the sociology of law, I actually make the argument that sociology of law is some kind of sociology. Now you would say, well, that's duh, right? In America, the kids say duh, meaning that's obvious, but it isn't. Because one of the most famous representatives of sociology of law in the United Kingdom actually makes the argument that sociology of law is part of legal sciences. See, not of sociology. So in that sense, I think it makes it's more than just semantics, let's put it that way, right? And then, of course, the second argument that I make is that this kind of sociology is perverted, with which, strong statement to make, of course, with which I argue that it is a form of advocacy rather than of analysis. And that's probably something, that is kind of the core of discussions on public sociology. So now, let me be very brutal now, and I know with some of these statements I definitely did not substantiate sufficiently in my paper, and maybe I cannot substantiate them, but I always think it's useful to call something black, and then if you tell me it's white sometimes, then we know that, right? So, but I'm not just trying to be cute either, so I hope I'm making some good arguments. So first of all, I call these the transgressions of the sociology of human rights. So basically blunders, okay? Not very valuable statements, which I'm making, Tony, in order for us to establish a sociological sociology of rights, right? So I don't want to be just negative about it. In terms of the activism of human rights, I really regret at this point that Brian Turner is not here, because he wrote at some point in one of his papers that Alasdair MacIntyre, he said, puts it brilliantly, that's a quote, put it brilliantly, that a value-neutral position can never discuss. He said, and McIntyre surely wrote that a political regime fell because